Good morning, everybody, and welcome to December's Employment Coffee Break briefing. Can't believe I'm saying that. We've somehow managed to get through about 15 of these over the last, well, just over a year, funnily enough, including the couple of brief interlude ones we had that were nothing to do with that employee life cycle. Today's session is the last one on that employee life cycle. We've obviously worked through recruitment, contracts and worker status. We've looked at various forms of discrimination and how to avoid and deal with those. We've looked at performance, we've looked at sickness absence, we've looked at disciplinaries, and we've gone right through to termination of employment with, as I say, those couple of brief interludes exploring things around the election, things in the Labour Party's proposals, and of course the couple of sessions that between us Nathan and I did on resolution of disputes, whether that's through ACAS and mediation that way, or whether it's through internal mediation, which was Nathan's previous session. And of course, a big thank you to him for covering that one for me. Hopefully he and I will be doing more of these either together or separately in the future. So if you did enjoy his session, and I hope you did, please let us know. And obviously something that is maybe more his area is something we can cover more in the future. Today's session then, post-termination issues. Like I say, it's the last one in this sort of employee life cycle we're doing. The employee's left now, so what we thought we'd cover just for today's session is the few bits and pieces that might arise after they leave. As always, I've got the Q&A, I've got the chat function in front of me. People have found the hands up or the thumbs up feature as well, which is always useful, so please do give me feedback as we go. Please do chip in at any time if you've got anything you'd like to say or add, and I'll try to deal with questions as they arise. Otherwise, unfortunately, everybody just has to listen to me talk. And beyond that, yes, the session is recorded, and as you know, the recording is made publicly available. All the previous ones are on the firm's YouTube page. This one will be sent to you, as well as the sort of summary feedback that I think the marketing team put together for us as well. So, before we dive into post-termination issues specifically, I think some of the content that went out said I'd cover briefly an update on the employment rights bills. Yes, the government have realised that they've managed to rush out a 100+ page document without kind of doing everything they thought they should or were doing. So there has recently been a new 53-page document dealing with some of the stuff they've missed, which gives you a pretty good idea of just how much of it was potentially not going to work first time round. So within that 53 pages, a little bit tongue-in-cheek at the start there, but it is fairly accurate. There is a lot of waffle in it about the way that 0 hours might work, the calculation of those, how the shift cancelling stuff was all going to work, and a lot of minor amendments to, as I said, they're tidy up the original document, really. It just goes to show how rushed that first version was. That said, 2 or 3 things to be particularly aware of. Obviously, no need for any action yet, because these things are unlikely to become law for another sort of 18 months to 2 years, but be aware. There is a proposal now in there for the limitation period for all employment tribunal claims to be extended to 6 months. Of course, that is currently 3 and has been for a very long time, as amended by any ACAS early conciliation process. But of course, what that does mean moving forwards is that claimants will have a lot longer to go through that process of attempted settlement, drafting their claim and ultimately issuing it to you, to the point where realistically allowing for tribunal administration, you may well not want to feel sort of safe, as it were, for 9 to 12 months after an employee has left or an event has happened. The other thing that's gone in there is, I talked about it when I was looking at the employment rights bill in a previous session. We've got this initial period of employment, which was sort of overlapping with this idea of a statutory probationary period, I suppose. It wasn't clear at the time how long that was going to be or what that was going to look like. Based on this brief update, that is now looking somewhere between 3 and 9 months. In effect, what that will be is the day one right, if it comes in, will kick in from day one, but there will also be this shortened initial period of employment where you're likely to be able to get away with condensed or less onerous processes in terms of terminating an individual's employment. They're kind of the big couple. There are 2 or 3 more. I think an update was circulated anyway for people who came to one of our previous sessions. If it didn't go to anybody on this list, I'll ask that it goes out along with the follow-up from this session. So, having done those and waiting really to see what happens next with the Employment Rights Bill, we will obviously update you as and when we know anything. Let's start talking about today's session and things that arise potentially post-termination. So, 4 things that I want to touch on today: post-termination obligations, post-termination restrictions and the difference between those. We'll talk a little bit about some of the issues that arise post-termination both ways. And in relation to post-termination restrictions, I will touch a little bit on their enforceability and routes of action for enforcing against potential breaches. We'll talk briefly about references. There's not a huge amount on that, but I just want to clear up a couple of points with those, a couple of common myths, and it'll overlap nicely with the discrimination session at the end. Because yes, there is such a thing as post-termination discrimination. It can and does happen, and the Employment Tribunal do have jurisdiction to hear about it. It won't surprise you to know that the provision of references or not can amount to a form of discrimination, depending of course on how they are presented. So that's the general overview for today. Obviously, the majority of this post-termination obligations, post-termination restrictions, we're going to be considering contracts, but there is also some underlying legal principles around those. Discrimination, of course, I'll touch on issues that have come up in the past, and if you want to go back and revisit any of the sessions which define some of the forms of discrimination, then by all means please do, or indeed we can cover them in a future topic, which I'll touch on right at the end. So, post-termination obligations versus post-termination restrictions sort of goes without saying, but we're talking about the difference between things that an outgoing employee must do, the obligations you're going to impose on them when they leave you, versus the things they must not do, i.e. the post-termination restrictions, sometimes known as restrictive covenants. So, obligations on termination. These are almost exclusively going to be set out in an employment contract, and they should be. A lot of them are common sense things. A lot of them are things that where there is an amicable exit, there's going to be almost no issue with whatsoever. But it's in those situations where the end of the employment relationship is more contentious that you are likely to get into a problem with some of these things, particularly where they're not expressly set out in contract or policy. So the big one, return of your property as an employer. It's always useful to have a very specific clause in the employment contract that requires an individual to do this, least of all for some of the reasons I'll come on to in a moment, but particularly where you might have disputes about ownership or an obligation to do it in the first place. I've got Update Social Media there and LinkedIn. What that is more to do with is the individual holding themselves out as continuing to still be employed. So one of the things that can go in either a post-termination obligation or a post-termination restriction clause is some kind of requirement for them to cease holding themselves out, to not appear as though they still work for you. Couple of obvious big reasons for that. Firstly, if they're at relatively senior level, you don't want the risk of a third party assuming that they still work for you and therefore have authority to do things on your behalf. Least of all entering into binding legal contracts. The other side of it, of course, is if and when you decide to cease that relationship, particularly if it's in contentious circumstances, you then don't want them to do anything that reflects poorly on you or risks damaging your reputation. So one of the classics there, as I said, is sort of updating LinkedIn in particular to show that they no longer work for you. But it is a sort of natural extension beyond that to other ways of not holding themselves out. The other thing a contract may contain, not always, and this is probably more rare than the other two, is how you will deal with internal and external announcements. So that is how the employee's exit is going to be communicated both to colleagues, but also to clients, customers, or the wider public. It can help to have a standard form of announcement that goes out whether internally or externally. We all know that fairly generic chosen to move on, pastures new, wish them the best kinds of statements. Nothing wrong with those, and they can just help to, I suppose, even out or perhaps soothe any difficulties that might arise on an exit, whether internally or externally. This isn't a session on settlement agreements. I did touch on them briefly when we were doing the ways of resolving disputes session, and if people do want a longer session on settlement agreements and how they work, that's something we can look at doing next year. But all three of these, if you ever exit somebody under a settlement agreement, are probably things you're going to want to include in them. Again, certainly the first two, and if you are exiting somebody using a settlement agreement, then you want to make sure that any compensatory payments is entirely or at least partly dependent on them returning company property. Internal and external announcements, again, can both be agreed as part of a settlement agreement. It's fairly common, particularly where there is some form of dispute or in a redundancy situation. And to be fair to them, individuals are often concerned about how their team perceive an unexpected exit. So all three things worth considering. Let's talk in a little bit more detail about probably the most contentious of them, which is return of company property. Now, I say return of company property. There is obviously a potential return of property both ways, depending on the circumstances. As the employer, you are going to want your property returned to you, particularly if you've got a member of staff who is largely contracted to work from home and may have quite a lot of equipment at home that actually belongs to you. On the flip side, if this is a dismissal following a period of suspension for misconduct, or it is a long-term sickness absence dismissal where the employee's been off for a long time, it is perfectly possible that you will have stuff on site that belongs to them. Now, this shouldn't be a particularly complicated point, because at the end of the day, if you own something, you're entitled to have it back. And funnily enough, whether you are the employee or the employer, you do not have any right just to hold on to someone else's property. I've mentioned one in particular in the middle there about disputes which sometimes arise over ownership. There's a couple of situations where this crops up, and I've mentioned one there because it crops up more than you might think. There are cases, and I've dealt with a couple actually on exit, where employers have tried to hold on to training certificates. I don't understand why, and I don't know why there's a dispute over this. I think it usually arises where an employee leaves and the employer believes or even has a contractual obligation for the employee to make payments back of any training costs. Now that's fine, that's a totally separate issue. It's probably in a contract somewhere and should be. It's something I'll touch on later in the session. But yeah, the actual certificate that says they've passed a course or have some kind of qualification, that belongs to the individual. I'm sure I don't need to tell anybody here that, but I thought I'd raise it because it is one that comes up from time to time. The other common dispute that you see over ownership of property is almost the complete opposite end of the spectrum, and it tends to be where you have a long-serving member of staff, usually in some kind of maintenance or support role. And what you often find is that when they start their employment, they will bring supplies or tools with them. And some of you will have already started to see where I'm going with this. Those tools get replaced over the course of 10, 20, 30 years. And when the employee eventually exits, you end up with a dispute as to whether the item was simply replacing something that was already theirs to start with, or whether the employer has bought it and has a right of ownership to it. Now, again, in a fairly amicable exit, that's something that's likely to be agreed upon. If the employer's got no reason to keep hold of those items, you may well just let them take them as a replacement for stuff they brought in the first place. But in contentious disputes, I've seen that be quite hotly contested. And indeed, it sometimes does become an issue that has to be determined in tribunal. So I think the one to be mindful of there, it's not necessarily a termination issue as such, but I think it's something that if it arises in your workplace and items are either brought in by an employee at the start and used throughout their employment, or replaced throughout their employment, you want to be very clear at the time it happens what the expectation of ownership is over those items. The last thing I want to talk about on return of property is what happens when parties refuse to turn property. Contrary to popular opinion, the police will not care. They are not going to go and kick down your ex-employee's door just to recover your laptop. It's hard enough to get them to investigate an aggravated burglary, as some people may well be aware. Trying to reclaim property that is ultimately subject to a civil dispute is not something they're going to be interested in. Realistically, the only way to enforce return of property, if there's no other agreement to the contrary, and quite frankly, even if there is going to be to turn up in the county court and get some kind of order for it to be handed over, or some kind of seizure order for it. It is an expensive process, it's a convoluted process, and that's why I think this is something ideally that will be resolved in advance where you've got a contentious dispute going on. As I was saying on the previous slide, though, if you're exiting under a settlement agreement, the easiest way to make sure an ex-employee returns company property is to make the ex gratia payment, in particular the compensatory element, conditional on them returning that property. I'm judging purely on the lack of a flashing thing on my screen that nobody's got any questions or comments on that, so I will just keep rolling through. Let's talk about final pay and your options for withholding pay, because of course that could potentially overlap with return of company property anyway. Things you generally don't have a choice on. Salary up to the termination date. Make sure that is calculated correctly. And again, actually, whether this is under a settlement agreement or any other form of exit, that is one that is sometimes contested, because you'll find payroll is done for the previous month and then it's for some reason missed in the month where termination takes place. Accrued but untaken annual leave. Couple of points to consider with this one. It is almost impossible to not pay somebody any statutory annual leave to which they are entitled up to the date of termination. There is some way of getting around it in relation to contractual pay, where somebody leaves in breach of contract or under a gross misconduct dismissal. But as a general rule, it is quite hard to get out of paying somebody any accrued annual leave up to the date of termination. Pay careful attention to payments in lieu of notice. So there's a couple of things to consider here. Firstly, you can only make a payment in lieu of notice if there is a contractual entitlement to do so, which means you need it in your employment contract, or it needs to be in the settlement agreement if you're signing that way. If you do not have a payment in lieu of notice clause, strictly speaking, making a payment in lieu of notice is a breach of contract. It won't be one with any particularly high value, of course, but it is on the face of it a breach of the employment contract because there is a notice period. Don't forget, if you are making a payment in lieu of notice, calculate it correctly in accordance with the provisions of the contract. There is a difference between 30 days, 1 month and 4 weeks. It's very, very rare that all of those are the same thing. And employees will notice. They will be very aware if you're trying to sort of scrimp them out of 1 or 2 days' pay. The other thing with payments in lieu of notice, and this particularly happens under settlement agreements, and I'll come on to it briefly in a moment, payments in lieu of notice are always subject to tax and national insurance. And if somebody has a contractual notice period, that must be paid in full and taxed accordingly, particularly under a settlement agreement. If you don't, you are in breach of income tax rules. Last thing to consider with final pay then is any additional contractual entitlements that might exist. This is where you need to be careful, going all the way back to our session on what goes in your contracts, carefully drafted bonus provisions as to when they get paid. Employees may be entitled to them during their notice period, they may not be. It will depend exactly on how the contractual term is drafted. So do make sure that if it is the case that they obtain their bonus, even if they're on notice or on garden leave at the point when it becomes payable, if they are entitled to do so, that should of course be received. Again, we don't want breach of contract claims arising over final pay. Withholding from final pay, and actually I've talked about this in the context of final pay, but actually most of these principles are going to apply across the board to any situation where you may want to withhold pay even during the course of employment itself. There's not very many situations where you can unilaterally make deductions from an individual's pay. Funnily enough, it's a fairly fundamental principle that if somebody does work, they get paid the amount they're expecting to be paid for it. And there are specific tribunal claims here. Obviously, it's a breach of contract, but there is also the unlawful deduction of wages claim an employee can bring as a very specific claim in its own right. So, situations where we can do it. Statutory deductions. So that's going to be PAYE deductions to all intents and purposes. Pension contributions are going to be in there as part of other lawful deductions. Student loans, which most people will be employing people who have a student loan repayment scheme for. Other lawful deductions may include things like an attachment to earnings order that's been filed by a court. If anybody's not familiar with those, they arise usually in one of two situations. Either an individual is in a significant debt, or more commonly, it is maintenance payments issued by a family court. That pretty much covers the statutory and general lawful deductions. Other situations where you're allowed to do it potentially under your employment or some other form of contract. This will be those additional deductions that we want to be able to make. So it's the damages to goods deductions. It's the you have to pay the excess if you're a driver of our vehicle and you're involved in an accident deductions. They need to be expressly set out in there, otherwise you cannot make them. The other one where you are generally allowed to do it as a matter of principle for common law, correcting previous overpayments if you've incorrectly paid somebody too much the previous month. The big caveat with that is it cannot cause hardship to them. So as a prime example, if you've accidentally paid somebody double their salary last month, you can't just not pay them this month. That's likely to cause them a problem. Some kind of repayment scheme over the next period of time is likely to be necessary. Not again an issue that often arises with sort of automated payroll and all of those sorts of things. Overpayments is unusual, and where they do happen, they tend to be fairly minimal. But again, this still applies to final pay as well. The individual has worked for the last month, for example, that they've been employed. They are still entitled to that salary, and so deductions do need to be in accordance with these sort of basic legal principles. Right, so that is it on pay, obligations, and that side of things. So I'm going to move on to post-termination restrictions. We'll talk about briefly what they look like. We'll talk about enforcement of them, and then we'll move on to the next part of the session. So, post-termination restrictions, incredibly useful thing to have tucked away in your employment contract, and for most people, they will look something like this. You usually have a clause, it tends to be tucked away towards about, I don't know, 17, 18, 19 of employment contract, usually the point where people have stopped reading it. And it will say something like, for a period of 6 months following termination, defined term, the employee, who is of course the employee under the contract, shall not directly or indirectly for or on behalf of a competing business, defined term, or for himself, herself, themselves, however you choose to draft it, obviously, not to do any of these things. And then you usually have 4 or 5 sub-clauses that will fall into one of these categories. We don't have time to go through them in a huge amount of detail, but I will just touch on the distinction between the 4 of these and how they work in principle. So what you'll generally have there will be a non-compete clause, and this is the one that will quite clearly say you will not go and work for a competitor. You are leaving us, company A, and this is where that definition of competing business that's set out there at the top is quite useful. You will not go and work for somebody who we consider to be in competition with us. They are one of the hardest contract clauses to enforce because they tend to be incredibly broad. I'll come on to enforceability in a moment, but the one to bear in mind is that non-compete clauses are basically saying you cannot go and work in the same business as us, despite the fact that you may have been employed by us for the last 20 years. They are quite draconian, they are quite harsh. You can understand why an employer wants them in there, but yeah, they can be a little bit tricky to enforce. Non-solicitation clauses. So what a non-solicitation clause will usually say is that for the period of 6 months, etc., 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 you will not seek to entice, solicit, or endeavour one of our customer or clients, i.e. outgoing company's customer or client to go and take up services elsewhere. It has the functional effect of a non-compete, but without actually being a non-compete. We're not saying you can't go and work for company B. What we're saying is you can't steal our clients to leave us and go to company B, which is a lot more reasonable in the grand scheme. Somebody can go and do a job they like. What we're doing is making it difficult for them to do so by poaching our clients or customers. A non-dealing clause will overlap in many ways with a non-solicitation clause, but again, actually is another step down. So whereas non-solicitation is designed to prevent an employee from, I don't know, going on LinkedIn and saying, "Hi everyone, I left company A, I now work for company B, why don't you come and have a chat with me here?" What a non-dealing clause does is prevents that employee from working for company B, and where an existing client or customer of company A comes to them by choice, dealing with that individual. So it's sort of the next step down. What it's designed to do is prevent those situations where they may not have actively tried to take away the client, but where the client has gone to the new company by choice. You will also see non-dealing clauses in relation to you're not allowed to deal with our suppliers or third-party contractors who we deal with as company A. And again, that's obviously designed to protect specific business relationships. The final one that is quite common, a non-poaching clause, that is almost always in relation to poaching your staff. And what that restriction will often say is something like, for a period of 6 months following termination, etc., you will not endeavour to encourage, solicit, entice one of our staff to leave us and come and work for you, basically. Those non-poaching restrictions can be caveated and often are quite heavily. It usually refers to senior staff. It may refer to people who are above or within a particular salary bracket. And at director level, it may kind of refer to other directors or people in senior management positions within the organisation. But they are the most common ones. They're the ones I probably see most of the time. The post-termination restriction clause itself will often contain other things as well. Obviously, I've got 3 or 4 defined phrases there: termination, competing business, which we'll come on to in a moment. You will also find that the post-termination restriction clause will probably contain the things I mentioned earlier about not holding yourself out as still being employed, not to make use of a company email address if you've still got access to it, things like that. It's usually tucked away in the same place as return of company property and all of those things as well. So that's generally what they look like. I'm assuming most people are familiar with these kind of restrictions actually being in a contract. So what I'll do in a moment is move on to the enforcement of those and how that sort of works. I've just seen the question pop in. Because I've moved on, I'll come back to it at the end if that's all right. So enforceability of post-termination restrictions then. The interesting legal quirk here is they are unlawful by default because they're a restraint of trade. We are apparently a free market economy, and therefore any individual is in principle free to go and set up a competing business, or indeed go and work for a competing business and do whatever they like, providing it is legal, to work and make money, basically. It's an interesting quirk that these kind of non-compete clauses have recently been deemed unlawful at federal level in the United States. They're very unpopular in Europe. And yet we still sort of cling to them. I'm not going to make a particular judgment one way or the other on them. I can totally see the business's reason for doing so, but I do often have sympathy with an employee who comes to me and says, I've been working in this job for 20 or 25 years, and now I've got this restriction that they're trying to enforce against me that stops me from doing that job. But I think that falls into the enforceability of them anyway. So, yes, they are unlawful by default, but common law and case law has all developed in such a way that tells us that a business can protect a legitimate business interest. Fair enough, that is for the business to identify. It can be its client base, it can be intellectual property, and it can be, in a sense, purely financial. But it is for the business to identify what that legitimate business interest is. You can't just say, we've got one. And the caveat to that is that it should be to the extent necessary. So the reason I highlight that one, and it's actually the very final point on the slide as well, if you are recruiting somebody at very, very junior level who is freshly out of university and is doing a graduate job with you, there is a big difference between the extent to which you need to restrict their future activities and the senior director responsible for R&D in your business who has 40 years experience and could walk into another employer next week and cause you a major problem. So that is part of the text. The restrictions shouldn't go any further than they need to. And much like many other areas of UK law, this entire thing is assessed on the basis of reasonableness. How reasonable are the restrictions in the circumstances in which they were imposed? And there's a lot of things that play into account here. I've talked about a few factors and I'll touch on them now. But the courts and the tribunals, and it is worth pointing out, strictly speaking, this would be a contract argument done in the county or high court, can take almost any relevant factor into account when deciding whether these restrictions are reasonable or not. So geographic scope. If you are a business that only operates in a very, very limited area in a small town, and the wording of your restriction purports to say that an individual can't work for any competitor anywhere in the UK, it is not going to be enforceable. You are not protecting a legitimate business interest in Norwich if your business is in Exeter and only in Exeter, unless you can justify that you have that national scope, I suppose. I'll touch on geographic scope again in a moment. I've got a useful illustration for that. Saturation of the markets, this is quite a useful one as well. And it's often tied into geographic scope. If you consider the argument, I'll use myself as an example actually. We obviously operate Christchurch Ringwood, particularly the Christchurch office, obviously part of the wider Bournemouth Christchurch Pool conglomerate. Got Southampton one way, got obviously quite a long way, but then obviously moving into places like Weymouth in due course the other. There are a lot of law firms in that area. And how saturation argument tends to work is it's all fine and good saying that I've left Fretton's and gone to work for competitor Law Co. But what you can't necessarily say is that any given client who chooses to go to competitor Law Co. went there simply because I was there. It could well be that there are just so many businesses of a similar kind in the area that they went there for any host of other reasons. The quote could have been lower. They might have preferred the website. They might simply prefer the colour scheme. They might have done work with somebody else in that firm at some point. And one of the difficult things with enforcing post-termination restrictions where you've got a lot of competitors in an area is the reason that the individual, the client or the customer has moved isn't necessarily the fault of your ex-employee. And there does have to be that link. Working for a competitor is not necessarily a breach in and of its own right. Even if it is it reasonable to enforce? The next question that often crops up is what is a competitor? So on the previous slide, I'd used deliberately capitalized competing business there because it should be defined, and it should be defined as narrowly as necessary. It's hard to enforce a post-termination restriction that says something like, we consider a competing business to be anybody who does work of the same kind as us, unless the kind of work you do is very, very niche or very, very specific. One way to perhaps help with defining a competitor is actually to list the people you particularly don't want an ex-employee to be working for. And that really narrows it down, because what you're saying is you can go and work for, I don't know, other recruitment agency, but here's the top 5 who we consider our actual competitors. You're not allowed to go and work for them for at least 6 months. 6 months there, useful one to bring me on to time limits. So if we jump back again to that one, I've got a period of 6 months there. It is very, very rare for most employees for a post-termination restriction of more than 12 months to be enforced. At senior level, in very, very niche organisations where it could be justified, you might get up to 2 years. but realistically 6 months is often more than enough for the business need to have been protected. It is for the employer to justify the length of it, and what's important here to bear in mind is that if a court, in that particular clause that I've drafted there, for example, deems that 6 months was too extreme, all they can do is draw a line through the word 6 there. They can't substitute it with the word 3 unless the entire wording of the contract sort of allows that to happen. Most people don't draft that way, and so you do need to think very, very carefully about how appropriate the length of the restriction is. You don't just put 12 months because it's the longest and you want to protect yourself for 12 months. If the nature of your business is that people re-engage on a 2, 3, 4 monthly basis, 12 months is 3 or 4 cycles of that, it's going to be considered too long. It's certainly going to be argued that it's too long. The last one I put on there, seniority at time of the contract. Yeah, this is important as well. It goes back to what I was saying earlier. Consider a large organisation that deals with maybe aeronautical R&D or something like that. There is going to be a big difference between the nature of the restrictions that you need to put in for their front of house staff than there is for the research and development team, for obvious reasons. One of the biggest mistakes that companies make when drafting post-termination restrictions is to simply have blanket ones in a contract that apply to everybody. And the problem with that is, if you're using the same argument to justify why your FD can't move to one of your competitors, as exactly the same argument that you're using for why your receptionist can't, then there is a difference in those roles, and a court is going to challenge you on that. It's a very obvious challenge. You're not protecting the same interest, so why is the scope of the restriction the same? I could very easily do a much longer session on post-termination restrictions and their enforceability, but as always, this is just a very quick whistle stop. So if anybody would like us to do a longer session on them in the future, to look at how they're drafted, to look at how they're enforced in more detail, that's fine. But I'm going to start kind of moving on to a few other principles briefly with enforceability and then the discrimination at this point. Otherwise, we are going to run out of time today. So just very quickly, I just wanted to highlight the geographic scope point that I was making on the previous slide. That is a 20, 25 and 50 mile radius from our Christchurch office. So just as an example there, you can absolutely imagine that if I had a 50-mile restriction in my employment contract, how many law firms there would be in that area. We are covering halfway to Brighton there, out towards the east. We've got Winchester, we've got Basingstoke just in there. We're just touching Bath to the northwest. And then, of course, we've got some fairly significant towns there, even within kind of the 20-25 mile radius. The number of firms there are in Southampton, for example. I really do think that many businesses that have the level of saturation that certainly our sector does, for example, would struggle to show that that was enforceable. This is always a worthwhile activity, actually, if you're considering a restriction. I had one recently where it was within a 100-mile radius, and that takes you to North France. And it was, obviously I'm not going to say which kind of business it was, but it was not the kind of place where you would expect people to be travelling from North France to make use of the business. So how we enforce post-termination restrictions? Well, ultimately we argue that they're a breach of contract. Fundamentally, that's what they're for. That is the idea behind putting them in a contract, and just with any other breach of contract claims, it gives you 2 options for remedies. Both of these are why it's the county or the High Court rather than the employment tribunal for the most part. Injunctions. Injunctions are literally an order from the court that says, employee, you are in breach of contract by doing this, stop it. And that is pretty much the principle of them. The biggest problem with injunctions is that they are very, very draconian. Courts don't like issuing them unless it's the only option available to them, because, to be honest, unless it's criminal behaviour, the idea of a court saying you must stop doing something is considered problematic by a lot of people. They are also quite an expensive process. It is a high court action, as I've mentioned at the bottom there. It is a very costly procedure to get an injunction. You're probably looking at sort of £10,000–20,000 to go through the legal process of obtaining one for one of these, especially given the nature of the potential arguments around enforceability of post-termination restrictions anyway. Your other option with pursuing a claim against an ex-employee is the financial losses that result from the breach. This is ultimately one of those cost-benefit analysis situations. It is always the problem with enforcement of post-termination restrictions. In order to pursue a claim for financial losses, there needs to be a financial loss that is of more value than your likely costs of pursuing the claim. Otherwise, there's absolutely no point in doing it. You may well get a declaration that there's a breach of contract, but you don't want to have gone through that entire process and recover 50 quid. Injunctions, similarly, it doesn't necessarily give you any benefit unless what is happening as a result of the breach is a significant damage to your business that maybe can't be quantified in financial loss terms. Obviously, at more extreme levels where somebody has left, and I know I keep going back to kind of the R&D, but we could use IT or software development as examples as well. Those are sectors where you could be suffering significant financial loss. Loss of intellectual property obviously factors in, loss of revenue, all of those sorts of things. And in those situations, you can absolutely see why somebody may go to the cost and effort of pursuing either one of these. That said, in the vast majority of cases, the advice that you give both to employees and employers when you're talking about post-termination restrictions is they're there as a warning. They're a very useful warning. You can take action. If you believe that somebody is in breach of them, then it does give you the right to take all appropriate steps that you would ordinarily for any other breach of contract. But at the end of the day, legal proceedings around them are expensive for both parties, and in the vast majority of cases don't necessarily achieve an awful lot. And as I've said at the end there's no guarantee of success. Courts are generally falling on the side of an employer when it comes to interpretation of these clauses over the last few years. But again, it's all fine and good having an order that says, yes, employee B is in breach of contract, but if there's nothing to be gained from doing that, then you do really need to make the decision as to whether you do actually want to go down court enforcement or not. It's not unusual to go as far as drafting a pre-action letter. We've done enough of them for people, and asking an employee to sign a document that is in effect a secondary undertaking that they will stop doing the thing they're doing, or that they're providing their confirmation that what they're doing is not in breach, so that we do know what it is that they're doing. And that's pretty much it on enforcement and post-termination restrictions, I think. So we'll move on briefly to references, because I'm conscious that, as always, I'm talking about an awful lot and I'm going to run out of time. So this is a form of reference that I'd imagine almost everybody on this session is familiar with. It's one of those references that doesn't say anything, but it's the one we all see all the time. Yes, I confirm that employee was employed from date to date in the position of X. And then this wonderful little no liability caveat at the bottom, arising out of or in connection with this, etc., etc. It's probably the reference most of us would give. It's probably the last reference most of us received, or some version of it. And it is about as useful as a chocolate teapot for doing anything other than confirming what somebody has said on their CV. The reason, of course, that we do this is because we are all somewhat scared of being sued one way or the other for giving a false, bad, whatever reference. So I thought, what was a quick, helpful exercise here? Let's go through a few reference-based myths just to clear these off. You can't give a bad reference. Yes, you can. The obligation, if you're going to give a reference at all, is to give one that is truthful and not misleading. There is absolutely no bit of law that says you cannot give a bad reference providing it is truthful. And the best example I can give of this is in regulatory systems where a certain type of reference and certain types of information must be given. And the best sub-example of that is in teaching. And when somebody goes for a job in a school that is subject to a regulatory reference regime, their previous employer, particularly if they were also a school, is obliged to give certain information about safeguarding, disciplinary, child protection issues. Now, it's very obvious that it would be a bad reference if you say, yes, we had a child protection issue with this member of staff and we've had to refer it to DBS. It is a bad reference, of course it is. The difference is it's also true, and you are obliged to give it in that situation. what the law says, as I said, is you can't give a misleading reference. That's where litigation arises. And we'll touch on it briefly in the discrimination element as well. But providing what you're saying is true, in principle, yes, you can give a bad reference. That said, I can fully understand why it'd be much better to give this, or indeed to refuse to give a reference at all than to take the risk. And I said that employees have to give a reference. No, they don't, not unless they're subject to a regulatory regime, and it's a requirement of the profession that a reference is given. We all know that refusal to provide a reference speaks significantly more volumes, actually, probably, than giving a bad one. References are confidential, so this is an interesting and slightly quirky one. Yes, they are, and there was a brief period where nobody was entirely sure whether, when GDPR came in, that they were disclosable under a subject access request. They were always excluded under the Data Protection Act. Yes, they still are. If you get a subject access request, a reference provided for the purposes of obtaining employment and a reference in that sense is still excluded. However, there is no guarantee that the recipient of a reference won't choose to disclose it to the employee if they wish to do so. And there is nothing you can do about it if they do. They are entitled to do that. It is not confidential in that sense. It is not provided without prejudice, and it is not something that you can claim any ownership of once you've given it to the requester. So do just be mindful that, okay, yes, they are excluded from data subject access requests in principle. They don't have to be disclosed in that way, and you don't have to provide it to the employee. But there are situations where an employee may end up seeing a reference that you've given. You can say what you like in a verbal follow-up. I've put that one in there a little bit tongue-in-cheek, but actually we do know that sometimes what is said in a follow-up phone call is very different from what's put on the reference form. That said, it is one to be careful of, because you never know who is recording a phone call, and given the point above, you never know whether that thing that is said in a verbal follow-up is going to make its way back to the employee in question. So that again is pretty much it on references. There's not a huge amount with these, and again, okay, I was maybe being a little bit snide in this document, but actually there's no reason not to provide slightly more than this if you choose to do so. Certainly a description of any role they've fulfilled, any activities they've done for you, any successes they've had. Very, very unlikely to lead to any kind of claim one way or the other. Right, post-termination discrimination, just for the last 10 minutes, and then I'll deal with any questions that have come in. So, post-termination discrimination, it does exist. And funnily enough, we all sort of think about the first 20 sections or so of the Equality Act when we're talking about discrimination. But actually, it's also allowed very specifically as a claim under Section 108 of the Equality Act. And there are three, as I've said, they're particularly common scenarios where Section 108 itself does kick in. Refusal to provide a reference. So because somebody has raised a discrimination claim, you refuse to provide a reference because they resigned in response to what they believe is discrimination, or indeed simply choosing not to do so because of their protected characteristic. They can all be forms of discrimination. Obviously very difficult to prove, but then so are most cases of discrimination to start with. A tribunal will read into the background. If discrimination is established during the course of employment, then an employer's refusal to provide a reference is probably going to be inferred to have been discriminatory. Refusal of any post-termination benefits in exactly the same way. Most organisations don't have some form of post-termination benefit, but I'll come on to an example of where one of those did arise in a moment. And actually refusing a right of appeal can be argued as a form of discrimination as well. If a dismissal was discriminatory in nature, even if the individual didn't necessarily have unfair dismissal rights, then refusing them to have the opportunity to raise that appeal, and particularly if they identify discrimination in their appeal, could be an act of discrimination itself. In principle, all of these can also be argued as a form of victimisation under Section 27 anyway, because the employee will make the case that the only reason these things have happened is because they've made a complaint of discrimination, if that's what the fact pattern allows for. So a few examples of how these work. So claims arising post-termination. This is a good example of that sort of post-termination benefits one. It is a real case, Clark and others versus various chief constables of different forces. The police forces had a disability gratuity. In effect, it was a payment that was made to staff on a long-term basis who had either developed a disability or who were disabled while working for them. These particular police officers all retired on ill health grounds. They became disabled after becoming injured at work. And ultimately, the police forces stopped paying out this gratuity post-employment, even though it was something that they had historically done. It was a very, very complicated argument, which I don't have 20 minutes to go through, unfortunately. And as you can see there, it went all the way to the Court of Appeal before anybody actually concluded that there was an issue here. But what the Court of Appeal basically said was, yes, this has to be discriminatory, because ultimately the reason it's not being paid to them anymore is the ill health retirement that was due to disability. And you can see there's an irony here in not paying a disability gratuity due to somebody who is left having become disabled. I'm not entirely sure what advice the various police forces got in this case, but it seems to have been some very, very backwardly applied logic. A few other potential examples of where discrimination can arise post-employment then. An employer continues acts of harassment after an employee's relationship with them is terminated. That seems a fairly obvious one. It could well be that this is a small organisation and it is the owner or the business owner who the individual has complained about harassing them, continues that act even after the employee has resigned, for example. That could give rise to either a distinct Section 26 harassment argument or an argument under Section 108. Reasonable adjustments is a good one, and this is again a slightly quirky one. I couldn't find a set case on this, but it is set out in the explanatory note of the Equality Act. And what it gives here is you've got an example of an employee whose employment contract said you have access to our on-site facilities for life. The employee is disabled and they then retire. It does actually run that the employer is still obliged in that situation to ensure that the employee has access to those on-site facilities or some comparable version of them. Otherwise, that is potentially a failure to make reasonable adjustments because it is the disability that's preventing them from accessing them. Of course, it's only where the obligation there is for full life access. It wouldn't, of course, ordinarily arise where you give access to your on-site gym, for example, but only during the course of employment. Victimisation claims then threats or some other detrimental treatment due to issuing a claim. So that's also going to be a Section 27 victimisation argument anyway. It could fall under Section 108. I've mentioned there it's a risk factor with costs and conduct of the litigation. Don't forget, costs in the employment tribunal are relatively rare, but cost awards can be made where a party acts vexatiously, maliciously in the conduct of the litigation itself. We have to be very careful as professional advisors when we're acting against a litigant in person, and costs, threats, and sort of overzealous use of legal knowledge where the other individual maybe obviously doesn't have that knowledge can be interpreted as discriminatory acts themselves. It may not give rise to a discrimination claim, but it may play into a costs argument at the end. So do be mindful of that if you're acting for yourself or if you have a particularly litigious representative one way or the other. So all things to be mindful of there with post-employment discrimination as well. We have got about 5 minutes, so I'll just talk about the next session first and then quickly come on to the questions so that anybody who doesn't want the answers to the questions can go if they need to. We will skip January session. The reason for that is the first Wednesday in January is probably the first proper working day back for most of us. And I'll give us January to have some breathing space where we don't need to think about major legal updates. Today's session is also the end of my planned one on the employee life cycle, where we've gone all the way through recruitment to now post-termination issues. So moving forwards, we can obviously come up with a plan ourselves. Nathan and I in particular, as well as our wider team, may have topics that we want to do. There's plenty of stuff I'll have ideas to talk about, and as you've probably noticed, it's difficult to shut me up once I get going anyway. But if any of you have got particular topics that you do want us to cover, please let us know. Contact me directly via email, LinkedIn, whatever the case may be, or respond to one of the emails back to the marketing team. We're quite happy to accommodate anything anybody wants to talk about. So I will stop there, and for anybody who does want to go immediately, then I would say thank you for joining these sessions for the last, well, just over a year now. If I don't talk to those of you who are clients or regular contacts in the next few weeks, and to everybody else as well, I do hope you have a very restful Christmas break, and we will see you at some point in the new year. As always, thank you for joining us. And now what I'll do is I'll turn to the questions, and we can do them a little bit less formally. So first question that cropped up, pile-on and annual leave. Can you advise how to address when an employee has pre-booked annual leave during the notice period that you wish to pay in lieu? Do we deduct annual leave from the notice period? That's a fun question. So there is no basic obligation to pay an employee for holiday that would have accrued during a payment in lieu of notice period. So what I would suggest you generally do in that situation would be to do the calculation up to the date of their termination date. And then beyond that, in a sense, it's up to you. You can be very, very nice and pay them for the leave that would have accrued during their pile-on period. I would suggest doing so, because if you don't, I think ultimately what the employee is going to argue is that they're probably more likely, at least, to take issue with the termination if it's not agreed. Do we deduct annual leave from the notice period? No, and the simple reason for that is that they are entitled to both if you're going to make both payments. So if you're going to pay somebody a notice period and an annual leave payment, they're not necessarily the same figure. They've got to have their notice pay and it's got to be taxed. If you're then giving them annual leave on top of that, then that was your choice, I think, is the answer to that. My gut feeling is this feels like a fairly specific situation, so if you want to offline that one with me, please do. Because I think it's one of those situations where it depends a little bit on the circumstances. So sorry, yeah, I know that wasn't a full answer to the question, but I think it's probably the best I can give you. Other question, how long after employee leaves do you have to provide a reference for? No, there's not necessarily a set period for this. There's no obligation to give a reference at all anyway, unless your regulatory regime requires it. If an ex-employee contacts you 5-6 years down the line, then you can choose whether you're going to give one or not. To be honest, you're probably only going to give that sort of standard template. Yes, I remember these people working for me for between these dates, and it was forever ago, and this was their job title. But no, there's no kind of set period. The only question would be how long you retain them for. That would be under your data retention policies. Bearing in mind a contract claim is up to 6 years, then you may want to hold on to something like that for about that time anyway. It's a question of how long would you keep their employee personnel file before you destroyed that. But no, to answer the basic question, there isn't kind of any set period about how long after somebody leaves that you're obliged to provide a reference or anything like that. And that's the only couple of questions I've had, so I'm hoping I've answered both of those. But again, if there are specific points and anybody wants to offline them, please do be my guest. Otherwise, thank you, everybody. Have a good break as and when you get there, and we will catch up in the new year, I'm sure.